Hello again. I'm Bill Blake, a partner in the Baylor Evnen Law Firm in Lincoln, Nebraska. For more than 35 years, my legal practice is focused on eminent domain, the power to take private property for public use. In this series of presentations, my partner, Jared Krause, and I will cover various subjects that make up the law of eminent domain, also referred to as condemnation. The area I will be discussing today is the arena in which we work. I do not mean the courts. We will cover the court process in later sessions. But today we are talking about the process of acquiring property. If we could select a session to be mandatory viewing by government attorneys, negotiators, and appraisers, this would be the one. Many of the people who work for condemning authorities do not understand the sense of frustration and anger that is so often expressed by property owners who are caught in the path of a public project. It is important to understand that the playing field is not level. The property owner is always trying to run uphill, and it's hard to do that without help from someone who thoroughly understands the rules of the game. So, what do we mean, running uphill? How is the property owner at a disadvantage? You begin with the property owner who just wants to be left alone, who is not looking to sell and not looking for an opportunity to take the public's money. They like it where they are, and they want to just keep doing what they have been doing. They want to be left alone, but they cannot keep doing what they have been doing. They are not given a choice. Let's look at a typical project. Say a city that needs a new sewage lagoon, and they need it on your property. We'll go through a dialogue with a government negotiating agent. Typically a very good person, good at their job, and they're just doing a difficult job. And they're talking to you, the property owner. The city sends out a notice to you, says, we want part of your property for our new sewage lagoon. Negotiator comes out, tries to buy the property, hands you the papers. You say, well, it's not for sale. Doesn't matter. We need the lagoon and we have selected your property, is their response. What you, the property owner, hear is, you have no choice. Well, you say, I don't want the lagoon over here where you want it. Please put it over there on the back 40, or it will cause me the least harm. No, they say. We'd rather have it here, next to your house. It will work better, and it will be less costly for us. What you hear is, you don't have a choice. We don't care if it causes you concern. We represent the public. They are important. You are not. Well, when are you going to take my property, you ask. When we are ready, next year or the one after that, they say. And what you hear from them is, who cares? We represent the public. Well, it's going to cost you a lot of money, you say. They respond, we will pay fair market value based upon our appraisal. You say, well, at least show me your appraisal so I can evaluate it and see if I agree. Oh no, they respond. We cannot let you see our appraisal. It would give you an unfair advantage. But we work for the public. When the negotiator tells the property owner that the owner cannot see the appraisal, what the owner always hears is, well, we all know it's lowballed, and we're going to try to cheat you, but there is nothing you can do about it. Well, maybe I should get my own appraiser and maybe an attorney, you say, with a little bit of disbelief and a lot of frustration. Okay, they respond, but it will cost a lot, and that will come out of your pocket. And on it goes. Property owners have very few choices in dealing with their own property, and they are working in a legal framework that the government agents understand far better than the property owners understand it. The property owner cannot say no. The property owner cannot say not this year or not this week. The property owner cannot say put it over there on that part of my land. The owner cannot set the price. The owner can often not see the appraisal that the government obtains as the basis for good faith negotiations. The owner is literally told by many agencies, you cannot see the appraisal, but you can trust us. It would be unfair to let you see it. Now, that is a ludicrous, absolutely insulting position for any government agency to take. But many condemning authorities will not let the property owner see their appraisal. I can't imagine anything more unfair or frustrating in this entire area of law. But this practice of hiding the ball persists with many public agencies. The owner often cannot set any terms of the transaction, and the owner becomes frustrated, angry, and does not know where to turn. Sometimes, as a result of that, the owner will do what they feel is the only thing they can do, and they'll try to set some odd, sometimes not beneficial terms, make outrageous demands just to try to get some bargaining power in a situation that frustrates them. Do you hire an appraiser? Well, that's expensive. Do you hire a lawyer? That's even more expensive. So you say to yourself, well, maybe I should just sign and take my beating. It's best just to get it over with. In our next session, we will discuss some alternatives to this and some strategies that an experienced condemnation lawyer may be able to use to help you level this playing field a little. We cannot promise to make it a pleasant experience, but there are winning strategies to help the process.